me know when to start. Yeah.
All rise. The African Court of Justice and Human and People's Rights is now in session. Judge President Dr. Rustam Atajanov presiding together with Judge Georgiadis Kaseke. The matter before the court is the Office of the Prosecution versus the defendant, Ms. Dushomo Ngala. Each team has been allocated 35 minutes of this honorable court's time. Mr. President, over to you.
Thank you. Hello, everyone. I would like to open this round. I would like to ask all the audience to be muted and your video turned off. And I would like to request the first prosecution counsel to begin the their oral, please. And please keep in mind that both teams, oralists, they are supposed to keep their videos on. We have to see you. So first prosecution counsel, you may proceed.
Your Excellencies, ladies and gentlemen, good morning. My name is Njoroge Kiania. I shall be the lead counsel for the prosecution. I shall take 15 minutes of this honorable court's time, while my co-counsel shall take 18 minutes and 2 minutes shall be reserved for rebuttals. Your Excellencies, today we are here in a case where the accused is accused of heinous war crimes. We have, before this honorable court today, we have victims who are seeking justice and believe that this honorable court shall grant them the same. The prosecution shall endeavor to prove before this honorable court that one, heinous war crimes contrary to Article 28D of the Malabo Protocol were indeed committed in Uzuri, and that the accused bears individual criminal responsibility for the commission of the same. On my part, I shall handle the first issue on jurisdiction and admissibility, which I shall do in 2 limbs. The first limb I shall tackle jurisdiction, while in my second limb we shall tackle the issue of admissibility. Under jurisdiction, I will tackle jurisdiction ration materiae of this honorable court. Article 3, as read together with Article 28A and 28D of the Malabo Protocol, establish the jurisdiction ration materiae of this honorable court, where it grants this honorable court original appellate jurisdiction, including international criminal jurisdiction. Seeing that the matters before this honorable court pertain unlawful confinement, attacks on planned protected persons, and attacks on planned protected property, these fall contrary to Article 28D of the Malabo Protocol. These fall within the ambit of this honorable court's jurisdiction, and therefore we submit that this honorable court bears the requisite jurisdiction ration materiae. On jurisdiction ration personae, Article 22A, as read together with Article 28D of as read together with Article 46G of the Malabo Protocol, establishes the office of the prosecutor, where it mandates this office to carry out investigations and prosecute accused persons who are accused of violation of the Malabo Protocol, either on its own motion or on referral by member states, or after a referral by the heads of state assemblies. The accused herein is accused of war crimes contrary to Article 28D of the Malabo Protocol, and despite her country of citizenship having not ratified the Malabo Protocol, the alleged war crimes were committed in a state party to the Malabo Protocol, and its victims were also citizens of a state party to the Malabo Protocol, which grants her and this honorable court the requisite personal jurisdiction pursuant to Article 46 EBs under its sub-articles 2A and 2C. As to jurisdiction ration temporis, pursuant to paragraph 30 of the fact pattern, we are informed that both Kedibonya and Salima ratified the Malabo Protocol in 2019, and the war crimes in question herein were committed between the last quarter of 2021 and the first quarter of 2023. Therefore, we submit that these war crimes were committed after the ratification of the Malabo Protocol, and therefore this honorable court bears the requisite jurisdiction ration temporis.
Counsel, what is the status of the Malabo Protocol? Can you tell us under international law and quickly, please?
Pardon, Your Excellency?
Could you tell the panel what is the status of the Malabo Protocol under international law? If you can briefly just describe it. Thank you.
The Malabo Protocol is a protocol establishing the African Court of Justice and Human Rights, which was ratified in 2019. And it establishes this honorable court to hear a wide array of matters, which include war crimes, genocide, mercenarism, and many other more cases which fall within its ambit. On to my second limb of admissibility.
Maybe the same question, Counsel, if you don't mind. Since we are dealing here with the African Court on Justice and Human Rights, isn't it proper that perhaps you should have first of all address us on the issue of whether the prosecution has exhausted local remedies? Why come to the court?
Your Excellency, I'd wish to cover that under my second limb on the admissibility of these issues.
Okay, very well, thank you. Okay.
On to my second limb on admissibility, I shall adopt a two-pronged approach, where in the first limb of my submission, I shall tackle the complementarity doctrine under Article 46H of the Malabo Protocol, while in the second limb, I shall tackle the issue of gravity, which is a requirement for issues to be admissible before this honorable court. On to my first limb, the prosecution submits that the complementarity doctrine under Article 46H of the Malabo Protocol has been adhered to. Article 46H under its sub-article 1 provides that this honorable court shall bear complementary jurisdiction to that of national and regional courts. In its sub-article 2, it provides scenarios where a matter may be declared inadmissible before this honorable court. One of the scenarios will be when a matter is either under investigation or prosecution by a state with competent jurisdiction. Number 2, when a matter has been investigated by a state of competent jurisdiction and it has decided not to prosecute. Number 3, where the accused has stood trial for the matters herein. And number 4, where the matters lack sufficient gravity. The prosecution submits that there have not been any investigations being carried out by either of the state parties as to the matters herein. Neither have any criminal proceedings been initiated against the accused on the same matters which are before this honorable court. As to the question of gravity, we wish to tackle that in the second limb of our submission on admissibility. On to my second limb on
Counsel, maybe just to ask you there, because you have clearly articulated that, and as you know, this court has what I can call twin jurisdiction on the issue of criminal liability and human rights violation. So, to which of these two does the principle of complementarity apply?
Pardon?
I'm asking, I don't know that you had my question. I was asking that this court has two divisions, the one on criminal, dealing with criminal cases, and human rights violation. And you have submitted on the principle of complementarity. And I was wondering, of these two, where does the principle of complementarity apply, these two jurisdictions?
The prosecution submits that the complementarity principle applies in our case right now. It applies to the international criminal responsibility. However, if a scenario is brought on the violation of human rights, the complementarity doctrine still applies to such an issue. On to the second limb, we submit that the gravity threshold has been met for the matters herein to be entertained by this honorable court. The gravity threshold was expounded in the case of Abu Ghada pre-trial chamber decision 2010, where it set out some of the indicators that are looked into to establish whether a matter holds the requisite gravity. They stated the nature of the crimes, the manner in which they were committed, the scale in which they were committed, and the impact on the victims. Further, in the case of prosecutor versus Lubanga in its pre-trial chamber decision, it also laid down some of the elements that speak as to gravity of matters before an honorable court. They stated, one, that a court shall examine whether the said crime was systematic or it was held in large scale, conducted in large scale. Number two, whether an accused is of a level that can be inferred to be among the senior individuals responsible for the commission of the crimes. And number three, whether the accused is one of the individuals who can be considered having the greatest responsibility over the crimes that occurred in a certain jurisdiction. It is our submission that Ms. Lusho Mongala, being the CEO of Asaya Roma, pursuant to paragraph 6 of the Statement of Agreed Facts, where she was the CEO and employees below her reported, gave her detailed reports regularly. She deployed AI, faulty AI, that led to the loss of dozens of people, and many more were injured. And therefore, we submit as the prosecution, she is among the people who can be considered most responsible for the commission of the atrocities against the Uzuri people.
Counsel, are you saying that the numbers that we have in this particular case with 37 deaths and 42 injuries, they fully satisfy the threshold of the widespread scale of the acts implied in this case?
Thank you, Your Excellency. In the Al Hassan Appeals Chamber Tribunal case, and in the prosecutor versus Mudaura, Kenyatta, and Ali, the courts, the chamber held that when you look at the issue of gravity should not only be looked at from our point of view. And in the Al Hassan case, it further stated that despite the number of people who are killed in the conflict
Counsel, we cannot hear you.
Being relevant, it was not a determinant of whether a matter. Your Excellencies, it is therefore our humble submission that the matters herein have attained the requisite gravity threshold, and therefore can be entertained before this honorable court. If there are no further questions, I'd wish to cede floor to my co-counsel.
You have alluded to the Hassan and the Mudaura cases, and those are cases that were determined by the International Criminal Court, whose governing or constituting documents are completely different from ours. What makes you think that those cases are either persuasive or binding on us to determining this matter, the issue of admissibility?
Your Excellencies, we submit that these cases are indeed persuasive. As we look at the history of the founding of the International Criminal Court, which before it had its predecessors, the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, where even in these tribunals, for example, there are some doctrines that were adopted by these tribunals. For example, the complementarity doctrine was in both these tribunals, which was adopted by the ICC in the enactment of the Rome Statute. And subsequently, the establishment of the African Court of Justice and Human Rights, it borrows a lot from these past tribunals and also from the International Criminal Court. And therefore, we submit that the cases we have submitted indeed have a persuasive basis towards this honorable court.
Okay, thank you.
Your Excellencies, I wish to cede floor to my co-counsel.
Judge Aziz, do you have any questions? Apparently, there are no questions. Thank you, counsel, for your presentation. I would like, just give me a second. I would now, you still have 40 seconds, but apparently you consider it done. So I would like to give the floor to the second prosecution counsel for this team. Please be reminded that you have to keep your video on all the time, and the floor is yours.
Thank you, Your Excellency. May it please this honorable court, and for purposes of record, my name is Counsel Hope McKenna, appearing for the prosecution. I'd like to start by mentioning that at the core of our legal system is the steadfast commitment to upholding justice, the protection of rights and individuals, and ensuring accountability for heinous acts that violate fundamental principles of humanity. The prosecution hereby submits and will show in our submissions that Mrs. Lusho Mongala deliberately flouted the laws and customs of war that targeted civilians, protected persons, and even property. Your Excellency, Mrs. Lusho Mongala cannot evade responsibility for these actions. Our pursuit for justice is firmly rooted in the principle that those who commit atrocities must bear responsibility and must face the consequences of their actions. In light of the above, this court under issue 2, which I will divide into 2 limbs, that there are substantial grounds to believe that the crimes committed pursuant to Article 28D of the Malabo Protocol in Uzuri, the crimes pursuant to Article 28 of the Malabo Protocol were indeed committed in Uzuri, and on issue 3 that Mrs. Lusho Mongala is to be held individually criminally responsible for the crimes pursuant to Article 46B of the Malabo Protocol. That being said, I would like to give mention to the first limb of my argument under issue 2, which is unlawful confinement. Article 9 of the ICCPR mentions and provides that a person has the right to liberty and the security of his person, but this right is limited only under the various procedures of law. This is also echoed under Article 6 of the African Charter on Human and People's Rights. That being said, I would also like to give mention to Article 42 of the 4th Geneva Convention. Article 42 of the 4th Geneva Convention states that the intermittent placing of persons into assigned residences by a detaining party should be done so only if this detaining party deems it absolutely necessary. I'd like to mention Article 42 in the light of the decision that was made in the case of Prosecutor versus Delilac in the International Criminal Tribunal of the former Yugoslavia. In this case, the court mentioned that the reasons which are given for holding these people in assigned residences must be serious and legitimate. And these people should be arrested and should be detained due to the fact that they have committed crimes or they are suspected to be parties who are hostile or have committed crimes of sabotage and espionage against the government. That being said, I would like to bring in light the facts of this case to this honorable court. Under paragraph 12.
Let me interrupt you here. I have 2 quick questions. First, you mentioned the Geneva Convention, certain particular articles. You are citing concrete provisions of these important treaties. What makes you think that they apply to this case? That's my first question. And second, what kind of conflict or what type of armed conflict we are dealing with here? Could you please elaborate on that? Thank you.
Much obliged, Your Excellency. The Geneva Convention is applicable in this case due to the fact that it has been ratified by the parties to the state involved in this case. And I'd like to give light to this case and establishing it as an international armed conflict. I regard it as an international armed conflict due to the provisions of the Common Article 2 of the Geneva Conventions. In Common Article 2 of the Geneva Conventions, it defines armed conflict as conflict between two or more of the high contracting parties, even if the state does not recognize one of them as such. It also states that these cases, these parties involved might have partial or total occupation of the territory. And in line with that, I'd like to give mention that under paragraph 5 of the fact sheet, we see that Kedibonye indeed gave Uzuri autonomy, legislative and administrative autonomy over that region of Uzuri. And as such, this conflict is safe to be deemed as an international armed conflict. That being said, I'd like to continue with the provision, as I was saying, under unlawful confinement. Yes.
Counsel, before you proceed, as you have forcefully argued that this should be characterized or be deemed to be an international armed conflict, why isn't it an international armed conflict?
Much obliged, Your Excellency. Under Common Article 3 of the Geneva Conventions of 1949, it provides for the definition of a non-international armed conflict. And while they were defining it, they stated that non-international armed conflict is only relevant where this is a conflict between a state and, for example, a rebel group, which is within that state. International armed conflict is conflict between two states, and as stated in the second limb, these people, the states in question, might have partial or total occupation of that region for it to become a state. In this scenario, we see that Uzuri was actually given autonomy over that region. Proceeding to my submissions on unlawful confinement, in paragraph 12 of the fact sheet, we see that the government of Kedibonye went as far as to infringe the privacy of the people of Uzuri in order to get data that was able to inform them of the people who are supporters of the case of the ULF, which is the rebel group in question. That being said, we see in paragraph 14 and paragraph 13 that they conducted mass arrests around the country of Uzuri. This being said, it was also stated in paragraph 12 that the majority of the people who are arrested were supporters. These were not persons who had participated in hostilities. These were not persons who had participated in riots. These were persons who merely supported the movement that was being conducted by the LF and the reunification with Salima. That being said, it is our submission, therefore, that the government of Kedibonye had infringed the right of Article 19 as provided by the ICCPR, the right to liberty and the right for freedom of expression of the people of Uzuri when they decided to arrest them. Your Excellency,
in November 2021, when there was this intense violent situation in Uzuri, are you saying that that situation wouldn't cause any serious or legitimate concerns on the side of the authorities, sufficient enough for them to justify limitations and detain at least some people who were involved, at least some of the protesters, because there were security concerns? Are you saying that those concerns were not serious enough?
Much obliged, Your Excellency. We do recognize that some of the actions committed were actually serious, legitimate reasons for security. But the question in place over here is most of the people who are arrested were people who are supporters. These were people who are using social media to express their opinions on the situation which was evolving in Uzuri. The people who are arrested and the people who are mostly affected by this unlawful confinement were those people who are arrested merely for giving expression and merely for being supporters for a rebel group.
What about the government's responsibility also to protect safety and security of other people around in this area who were not involved in riots? What do you say?
Much obliged, Your Excellency. The government does have the role to protect the people who are being affected by these riots, but furthermore, the government also has the role to ensure that they do not infringe rights while they're performing their duties. And in this case, the government of Kedibonyi has infringed the right to liberty, the right to freedom of expression, and furthermore have committed the grievous crime of unlawful confinement among the supporters of the ULF.
Right of liberty, is it an absolute right or is it a relative right?
The right to liberty, Your Honor, is a limited right by various provisions according to the law. And as I had provided under Article 42, it had also echoed the same, that it is also a limited right.
You may proceed.
As I would like, yes, much obliged, Your Excellency. Proceeding over to the second issue, which was the intentional attacks against planned protected persons and protected properties. I'd like to give mention to Article 4 of the 4th Geneva Convention, which defines planned protected persons as persons who at any given moment or time find themselves in a situation of conflict or occupation. These people include, but are not limited to, medical and religious personnel. They include prisoners of war, they include civilian population, humanitarian aid staff, and many other people. I'd like to now give mention also to Article 13 of the 2nd Additional Protocol, which provides that the civilian population shall be protected from military operations. The same is echoed under Article 48 and 51 of the 1st Additional Protocol. These protocols provide that in any occurrence of a military operations, civilian life should be the utmost, should be the one that should be protected at all costs. That being said, I'd also like to give mention to Article 57 of the 1st Additional Protocol, which states that precaution should always be taken to spare civilian lives in line of conflict that arises due to military operation. I'd like to direct this honorable court to the fact pattern under paragraph 21, where we see the KAF releasing the bad target AI, which led to the death of 37 and the injuring of 42 innocent civilians. We see the KAF approaching these people, and their bad target AI opens fire, which leads the people to throw stones, because this is a natural knee-jerk reaction when a threat is posed to someone. Your Honor, in line with the doctrine of proportionality, this is a situation of stones versus guns. It does not in any way, proportionality has not been given thought in this situation due to the fact that the KAF are attacking people who are using stones. And these stones were only thrown after the KAF had posed a threat against the people who are demonstrating in that area within their rights. I'd also like to give mention to the attacks which were committed in the mountainous regions of Uzuri by the ADOM AI program. ADOM AI deliberately attacked churches and sanatoriums in that area. This led to the killing of a priest.
Counsel, before you start talking about ADOM, you mentioned certain state, non-state actors involved in this particular case. Let me ask you this question, and let me come back a little bit to the qualification of the conflict on which your stance seems to be very, very firm. What makes you think that ULF, on the other hand, ULF as a group, did not have ability to devise military strategy or to have any other elements that would turn this group into an organized armed group and so in this manner justify the statement that we are also dealing here with NIAC, non-international armed conflict?
Much obliged, Your Excellency. It is our position as the prosecution that in as much as the ULF had integrated with the people of Uzuri in that mountainous region, these people were only in the streets to demonstrate. These people were not being told by the ULF to go there and start conflict with the KAF. The people were only demonstrating against the KAF. They were within their rights to demonstrate against the KAF operations. And these people only threw stones once a threat was posed to them after the bad target AI opened fire, and it led now to the killing of the 37 and injuring of the 42 innocent civilians.
So they didn't have significant control over parts of Uzuri. They didn't have ability to command in their own hierarchy. The commanders didn't have ability to control their subordinates within the group.
It is our submission as the prosecution in this scenario that in as much as the ULF are present and do have dominance in the region of Uzuri, the KAF absolutely have, according to the provisions of Article 13, while carrying out military operations, at all costs, they should always protect civilian population because these are protected persons. The only time civilians are going to be faced with a situation of hostilities from the military is when the civilians themselves take part in direct hostilities towards the military personnel involved in this scenario.
Thank you. You may proceed.
I'm much obliged, Your Excellency. As I was giving mention to the Adom AI strikes that led to the death of a priest, 4 of his acolytes, and many unnamed number of civilians in a church where this priest was carrying out his functions of a religious burial ceremony. It was also stated that 10 days later, from the attack that was done in the church, we see the KAF furthermore going ahead to attack a sanatoria, which led to the death of medical staff and many wounded people in that region. Your Excellency, I'd like to give mention to Article 19 of the First Geneva Convention, which provides that medical units shall be protected and respected at all times during the course of armed conflict. In this scenario, we see the KAF launching attack against a sanatorium where medical staff and wounded persons are placed in that region. It is therefore our submission as the prosecution that the war crimes pursuant to Article 28D of the Malabo Protocol have indeed been committed in the region of Uzuri, as we see the KAF launching all these attacks against the people in those regions. I'd like now to go over to my third issue, which is involving Mrs. Lushomongala. It is therefore our submission as the prosecution that Mrs. Lushomongala is to be held individually criminally responsible for the crimes committed pursuant to Article 46B of the Malabo Protocol. I'd like to give mention to Article 46B of the Malabo Protocol, which states that a person shall not absolve himself or herself of individual criminal responsibility by virtue of his official position, or that the orders were sanctioned by a superior, or he was in a supervisory role over the attacks that were committed. But it is also stated under under Article 46(6) of the same protocol that legal persons shall not exclude criminal responsibility of natural persons who are perpetrators and accomplices to the same crimes. That being said, Your Excellency, I would like to use the basis of the case of Prosecutor versus Enver and Amir Kabura, which was decided in the trial chamber of International Criminal Tribunal of the former Yugoslavia. In this case, they set out the requirements that are supposed to be met so that a person can be held liable for the crimes committed by his juniors. In this case, Mrs. Lushomo for the crimes committed by the usage of her AI program. The first requirement was there has to be a superior subordinate relationship between the perpetrator and the accused. And clearly in our case, we see that Mrs. Lushomongala indeed had a superior role over her AI program due to the fact that in bad target AI, the servers were connected to both the soldiers and a Sayaroma company. Therefore, when the soldiers were approaching the 250 persons, Mrs. Lushomongala was in her limits able to see that due to the limitations provided by the use of her AI, she should have been able to shut down that program due to the fact that her AI can only function in a region where there's only up to 50 individuals. Her AI would be deemed faulty when it is in a region of more than 50 persons. And we also see the fact that Mrs. Lushomongala deliberately employed the usage of Adom AI when she knew it was a faulty AI program, yet she allowed it to be taken to the battlegrounds. And also the second requirement that was set out in this case was whether the superior was in a position to know that the subordinate would commit this crime. And before I proceed, I would like to seek 2 minutes of this honorable court's time in order to finish my arguments.
I would allow that.
Much obliged, Your Excellency. The second requirement that was set out was whether the superior was in a position to know that the subordinate had or would be able to commit these crimes. Your Honor, in paragraph 24 and 25 of the fact sheet, in line with the provisions of Article 13 and 57 of the additional protocols, we see Mrs. Lusho Mongala deliberately not taking caution of civilian population when she takes out a faulty AI program to be used in a military operation that led to the death of priests, medical staff, and a numerous amount of civilian population. That being said, the third provision that was meted out in this case was whether the superior was able to prevent the commission of these alleged crimes. And it is our position as the prosecution that indeed Mrs. Lusho Mongala was in a position to prevent the commission of these crimes due to the fact that, one, the servers that are being used to control these AI programs were not fully autonomous to the KAF, but she also had an opportunity to control how these servers were being used. Secondly, by taking out a faulty AI program and after being warned of the things that faulty AI program might do, she still deliberately allowed it to be taken to a battlefield, and she did not take any precautionary measures to ensure that protected persons and protected places were indeed protected. And therefore, it is our prayers in line with these arguments as the prosecution that this honorable court finds that the case against Mrs. Lusho Mongala of war crimes is admissible before this honorable court, that there are substantial grounds to believe that the war crimes pursuant to Article 28D of the Malabo Protocol were indeed committed in Uzuri, and that there are substantial grounds for Mrs. Lusho Mongala to be held individually criminally responsible for war crimes pursuant to Article 46B of the Malabo Protocol. It is also our prayer as the prosecution that this honorable court finds that Asaya Roma is liable to pay for reparations for the victims who are affected due to the disastrous deployment of Asaya Roma's AI program and any other orders that this honorable court
Counsel,
may
your
deem
time is
fit.
up.
Much obliged, Your Excellency.
Thank you, Counsel. You may now turn your videos off, both of you. I would like now to call to the floor the counsel the first defense counsel of the opposing team. Please keep in mind that both of you also have to keep your videos on. I would like to ask our colleague to please take care of the time of the timer.
Conclude. Video no dey turn on.
If there is a technical difficulty with your video, please report that to the clerk. Counsel, I can't hear you.
Your Excellency, hear me?
It's constantly interrupted. It's constantly interrupted. Mr. Wenger, can I ask you to assist in this case? Yep.
Team 71. I think you are hanged. So I think something to do with your network.
It's frozen. Perhaps you can turn your video off and try to speak.
Can your Excellency now?
We can hear you now, but your video is frozen.
Could you try to speak now?
Yeah.
Okay. Am I audible, Your Excellency?
Not really. Could you turn your video off and then you try?
Okay.
So now, can you try speaking?
Okay. Am I audible now?
Yes.
Can Your
Yes.
Excellency hear me? Okay. If it may please the court, I seek to continue without my video on for network reasons.
Yes, you
Thank you,
may.
Your Excellency. May it please this court, entering appearance is KT Philip, Leonard Senior Counsel for the Defense. Appearing alongside with me is my co-counsel, P. Usio Sefer. Both of us shall be addressing this court. And I shall be addressing this court on two main grounds, on the grounds of jurisdiction and as well on the grounds of admissibility. Moving on to the first ground, which is on jurisdiction, I shall be relying on the following authorities. Article 46E, sub 1 and 2 of the Malabo Protocol, the case of ACHPR against Libya, citation provided in page 5, footnote 1 of our defense brief, the case of Falana against Republic of Benin, citation provided in page 5, footnote 2 of our defense brief, and the case of Falana against the African Union. This case has not been provided in our defense brief. I came across it during my research and it is pertinent to my case. The citation is 2012, 1 AFCLR 118, page 128 at paragraph 73. Your Excellency, the African court in the case of ACHPR against Libya highlighted 4 ingredients of the jurisdiction of this court. The first ingredient is jurisdiction ratione materia. The second ingredient is jurisdiction ratione temporis. The third is jurisdiction ratione persona. And the fourth is jurisdiction ratione loci. Your Excellencies, the court did not just mention these elements. It went further to convince itself that all these elements are present before it entertained the matter. Furthermore, the African court in the case of Falana against African Union declared that it lacks jurisdiction ratione persona, and on that basis, it dismissed the case. Your Excellency, these two cases shows that the element of jurisdiction, all these 4 elements, must be proved concurrently. All must be present before the court will have jurisdiction, and absence of one is capable of denying this court jurisdiction. Your Excellencies, I shall be contending in this instant case that jurisdiction ratione temporis, that is the temporal jurisdiction of this court, is missing, and the relevant laws regulating the temporal jurisdiction of this court is contained in Article 46E sub 1 and 2 of the Malabo Protocol. For the purpose of my address, Your Excellencies, I shall be dividing temporal jurisdiction into 2. The first is temporal jurisdiction with respect to the Malabo Protocol.
Counsel, let me interrupt you here. Let me ask you just one quick question. When exactly did the Malabo Protocol come into force? Could you remind us, please?
Okay. In the statement of facts as provided, particularly in paragraph 31, the Malabo Protocol came into force in 2019, Your Excellency.
2019?
Yes, Your Excellency.
Okay, proceed, please.
And the relevant laws regulating temporal jurisdiction of this court with respect to the Malabo Protocol is Article 46E sub 1 of the Malabo Protocol, where it's clearly stated that the court will only have jurisdiction over those offenses that were committed after the Malabo Protocol comes into force. And as I said earlier, the Malabo Protocol came into force in 2019. The issue with regards to temporal jurisdiction of this court, it with respect to state parties, with respect to Salima. Paragraph Article 46E sub 2 of the Malabo Protocol provides that this court will only have jurisdiction over those offenses that were committed in the state after that state has ratified the Malabo Protocol. Looking at paragraph 31 of the statement of fact of this case, it only provides that the Malabo Protocol itself came into force in 2019. The only fact that tells us whether Salima has ratified the Malabo Protocol is that it only states a blanket assertion that Salima has ratified the Malabo Protocol. However, it did not tell us the particular date, the particular year that Salima has ratified the Malabo Protocol, so as for us to ascertain, so as for this court to ascertain whether Salima has ratified the Malabo Protocol before these offences were committed or after the offences were committed. Your Excellencies.
Counsel, from the facts that you are saying, it is not in dispute that Salima has ratified. Of what relevance is the date? Because I would assume that once we have that understanding that there has been ratification, then the state has ratified and the protocol is binding.
Okay. Thank you, Excellency, for that.
Why are you making heavy weather of the date?
Okay, the date is very relevant so as to satisfy Article 46 E sub 2 of the Malabo Protocol. Those offences must be committed before the after the ratification and before the ratification of the Malabo Protocol. That is to say, those offences in question must have been committed must be committed after the ratification. And offences committed before ratification, the court will not have jurisdiction over those offences with respect to state parties. And thus, we are left with an ambiguity in the statement of fact because it did not provide the specific date for the ratification of the Malabo Protocol by Salima, so as to know whether it was after those offences that were committed that Salima quickly ratified the Malabo Protocol so as to give this court jurisdiction, which in this case, the court will not have jurisdiction because
doesn't the statement of facts clearly suggest that the alleged war crimes in question, they all took place on the Kidibonia territory between 2021 and 2022. So meaning, in other words, after the ratification of the Malabo Protocol. Why are you bringing up the Salima all the time?
Your Excellency, the statement of facts said the Malabo Protocol came into force in 2019. However, Salima, there was no information as to when Salima ratified the Malabo Protocol. However, it is only logical to conclude that Salima ratified the Malabo Protocol after 2019. However, after 2019 is ambiguous. It may be 2020, 2021, 2022, 2023. However, the offences were all committed in 2022. So if Salima ratified the Malabo Protocol in 2023, after those offences were committed, this court will not have jurisdiction because the Malabo Protocol does not have retroactive effect. Thus, the temporal jurisdiction of this court in this instance case is missing because the date that Salima ratified the Malabo Protocol is unknown. It's unknown. It can be any date after 2019. And as such, the African court in the case of Falana against the Republic of Benin says that the court must satisfy itself that it has jurisdiction. And jurisdiction is very fundamental, such that any exercise of any jurisdiction in a case where the court does not have jurisdiction will render the whole proceeding from the beginning to the end null and void. Thus, this court cannot exercise jurisdiction on the basis of speculation and presumption. There must be cogent and verifiable facts that this court must point to that it has jurisdiction. And in this instance case, it is not possible because the date that Salima ratified the Malabo Protocol is unknown, so as to know whether those crimes were committed before or after ratification, Your Excellency. And it is on this basis I pray that this court make a declaration that it does not have jurisdiction to entertain this matter. Moving on to the second ground of my argument with respect to admissibility, Your Excellency, I shall be relying on the following authorities: Article 46H sub 1 of the Malabo Protocol, Article 46H sub 4 of the Malabo Protocol, Rule 50 sub 2 paragraph E of the Rules of Court of the African Court of Human and People's Rights, Rule 40 sub 2 and 3 of the Rules of Court, and as well the ICC decision in prosecution against Katanga, citation provided in page 9, footnote 6 of our defense brief. And in contending that this court and this matter is not admissible before this honorable court, Your Excellency, I shall be making my argument on two main standpoints. The first standpoint is that local remedies have not been exhausted. And the second standpoint is that Salima has capacity to investigate and prosecute the defendant. With respect to the first standpoint that local remedies have not been exhausted, Rule 50 sub 2 paragraph E of the rules of this court provides that before a case before this court will exercise any jurisdiction, or before this court will admit any matter, the state referring the matter must satisfy the court that it has exhausted local remedies. Article Rule 40 further goes to provide that it is not enough for a state to merely make a blanket assertion that it has exhausted local remedies. The state must provide copies of evidence of exhaustion of such local remedies and the inadequacy and undue delay of such local remedies. In this instance, it is possible, Your Excellency, for the Republic of Salima to say that they've exhausted local remedies and provide evidence of same. It is not possible. Particularly paragraph 8 of the statement of fact provides that the first paragraph 28 of the case fact provides that the first step of action that Salima took was to refer the matter to this court, Your Excellency. They did not investigate before referring this matter. They did not prosecute. They refer the matter before they even take any action with regards to investigation. Your Excellency.
Counsel,
So,
Counsel, may I interrupt you for a very quick question? What is the relevance of the principle of exhaustion of domestic remedies to this case?
Okay, the principle of exhaustion of local remedies is with respect to the right principle in international criminal law, as well stated in Article 46H sub 1 of the Malabo Protocol, that this court only have complementary jurisdiction with respect to national courts, and national court must take steps to investigate matters before referring the matter to this court. And as such, this is the relevance of the principle of complementarity and exhaustion of local remedies with respect to the admissibility of this matter, Your Excellency. Local remedies must first be exhausted. To the second standpoint, to my second standpoint, which is Salima has capacity to investigate and prosecute.
Counsel, sorry, just before you proceed on that issue of exhaustion of local remedy,
yes,
isn't it the position that this court has original jurisdiction in the crimes such as the ones that are placed before the court? Does the principle of exhaustion of local remedy apply when this court is exercising its criminal jurisdiction?
Your Excellency, the Malabo Protocol is the protocol that gives this court criminal jurisdiction.
Yes.
And the Malabo Protocol itself provides in Article 46H sub 1 that this court shall only exercise complementary jurisdiction with respect to national court. And complementarity deals with exhaustion of local remedies. That is to say, even in criminal matters, in line with Article 46H sub 1 of the Malabo Protocol, states must make an attempt to exhaust local remedies before referring the matter to this court, Your Excellency. Moving to my to my second standpoint, which is Salima has capacity to investigate or prosecute the defendant. The only issue, Your Excellency, that Salima had from paragraph 28 of statement of fact was obtaining the accused, that the accused has fled their country. However, we must understand paragraph 28 serially. We must look at the paragraph serially and look at the chain of events. And paragraph 28 lines 2 states that Salima referred this matter in November 2022. They referred this matter to this court. And in paragraph 28 lines 5 provide that Salima issued an arrest warrant. It was then they discovered that the defendant has fled. That is to say, they already referred the matter to this court before making an attempt to investigate the defendant. And as such, the defendant has a case before this court. He doesn't have any business to do with the National Court of Salima because his case is pending in this court. In fact, hearing this matter before this court and the National Court of Salima hearing the matter is an abuse of the court process, Your Excellency. And as such,
Counsel, would you like to take additional time?
Yes, Your Excellency, my time has exhausted. I plead for 2 additional minutes for me to round off my argument, Your Excellency.
Additional time granted.
Thank you, Your Excellency. Thus, from the chain of events in paragraph 28, we get to know that it was in November that Salima referred the matter to this court. And it was in December, a month after emphasis on a month after that they launch an investigation. That is to say, this court is they've already referred the matter to this court before launching investigation, and at that point, the defendant has no business to do with Salima. He only has a business with this court to appear before this court and prepare his defense. Thus, it is not a defense to the prosecution. It is not an argument that the defendant is not available for prosecution so as to justify non-exhaustion of local remedies. It is not a defense because the referral comes first before they took attempts to investigate the defendant. And it's on this basis, Your Excellencies, I am making two prayers. The first prayer is that this court should make a declaration that the matter before this court is not admissible on the basis of non-exhaustion of local remedies. And the ICC in the case of prosecution against Mr. Katanga held that the relevant fact that the court should consider is relevant fact as they exist during the admissibility challenge. Thus, the accused is before this court, the defendant is before this court, and this court should encourage the Republic of Salima to go and exhaust local remedies. This action should be stayed for Salima to go and exhaust local remedies before any jurisdiction will be, or before this case will be admitted before this court. Thank you, Your Excellencies. I am grateful. I shall now defer position to my learned co-counsel to address this court on the remaining grounds.
Thank you, counsel. Thank you. I would like to call to the floor the second defense counsel. Please try to turn your video on now, and we will see if it works with the sound. Counsel? Can you hear us? I see that they will be using one and the same account in my understanding. So could you please speak?
They're connecting their audio, Mr. President.
Mm-hmm. Okay, we'll wait.
Defense, could you speak?
Yes. Am I audible?
Yes. Yes. You may proceed.
Good morning. Hear me?
Yes, we can. Counsel? Apparently we lost you again. Maybe you can switch off and switch on again. There are technical difficulties apparently. Counsel?
Good morning, Excellencies. Am I audible?
You are. Can you speak up a little bit because it sounds from afar?
All right. Can you hear me better now?
Yes, exactly. It's very good now. You may start.
Thank you very much, Excellencies. May it please this court, entering appearance is Peace Usiosef, co-counsel for the defense, and I'll be elaborating on issues 2 and 3 as provided in the statement of agreed facts. On issue 2, the question before this court is whether there are substantial grounds to believe by the crimes of unlawful confinement, intentional attacks against planned protected persons, and attacks on protected property took place in Uzuri. To this, Excellencies, the defense submits in the negative. On the first crime alleged, which is a crime of unlawful confinement, Your Excellencies, It must be stated that the right to the freedom of movement is not an absolute right, particularly in cause for an armed conflict, as states can derogate from this right to protect civilians from being caught in the crossfire in the midst of the conflict, and to protect members of the armed force from acts of sabotage and espionage. Your Excellencies, Article 5 and Article 42 of the Fourth Geneva Convention informs us that civilians can lose their rights and privileges when they are suspected of or have engaged acts as a hostile to the state. And also informs us that states can resort to measures of control and security as regards protected persons. Article 41 informs us furthermore that these measures of control and security includes being placed in assigned residences and internment. Your Excellency, paragraph 8 of the Statement of Agreed Facts informs us after the death of one Mady Sekao, there was total breakdown of law and order in Uzuri. There was sit-ins organized, roadblocks, riots, occupation of local government buildings, stones and projectiles were thrown at police officers. It was therefore pertinent for the government to step in to confine these persons to not just protect themselves, but also to protect members of the armed force. Your Excellencies, it must be stated but the government did not even resort to assigned residences or internment. Rather, what took place was simply confinement in their houses for the purpose of surveillance and supervision. As we can see from paragraph 15 of the statement of facts, these persons were allowed to live at predetermined times for recreational activities, for medical checkups, and for purchase of groceries. Article 5, particularly the commentary on Article 5, tells us that assigned residences include taking the person from his domicile and placing him in another locality where that person can be easily supervised. It also informs us that internment is a worst form of services, as these persons are not just taken from the houses, but are placed in a camp with other detainees. Thus, what happened in this particular case was legally justified, as these persons posed a threat by their presence on the road. First, they could be harmed and caught in a crossfire. Second, they could also prejudice the military operations of the Kenyan Armed Force. Your Excellency, it must be stated that even in light of the fact that these persons were not placed in assigned residences or interned, the procedural requirements stipulated for the confinement of civilians was followed by the Kenyan government. From paragraph 15 of the statement of facts, we can see that courts. Your Excellency, I can't hear you. I can see you are speaking, but I can't hear what you're saying.
Mr. President, your mic is
Yes.
muted. Yeah.
The microphone froze for some reason. Council,
right.
let me ask you, are you saying that the confinees in question that you are talking about here, they are not
Yes, Your
entitled
Excellency.
to their protected status under Articles 4 and 5 of the Fourth Geneva Convention?
Yes, Your Excellency, that will be particularly argued on the second issue. Before I
Okay.
proceed, I would like, thank you very much, very much obliged, Your Excellencies. I would like to say that the procedural requirements stipulated in Article 43 was followed in this case, as courts were established to review the confinement of these individuals. And if it was deemed that they be confined, they also had the right to appeal, and they could even appeal to the stage of the Supreme Court. So, the legal requirements and the procedural requirements stipulated for the confinement of civilians was, established and followed in this case. Then, to the question posed by Your Excellency, it particularly will be established in issue 2, where the question is whether there were intentional attacks against protected persons in Uzuri. Your Excellencies, Article 28D sub BI of the Malabo Protocol states that intentionally directing attacks against civilian population and individual civilians, particularly when they have not participated directly in hostilities, is a war crime. The question before this court is whether these persons have not lost that protected status. Your Excellencies, I can see you're straining to hear me. Can you hear me? Am I audible?
Constantly interrupted. The technical problems, I think.
Oh, I apologize for that, Your Excellency.
You're breaking. Sometimes we can't hear some of your submissions.
I'm very sorry for that, Your Excellencies. My technical team will try to work on that. But can you hear me now? Am I audible now?
Yes. Yeah, that
Thank
is
you
much
very
better.
much, Your Excellency. Thank you very much, Your Excellencies. Your Excellency, the question before us is whether these persons did not lose their protected status by direct participation in hostilities. There is no statutory definition for direct participation in hostilities. However, the ICRC released a guidance which is a persuasive authority before this court. It defined direct participation as acts carried out by individuals as part of the conduct of hostilities between parties in an armed conflict. It also stated three elements, which include the threshold of harm, direct causal link between the acts and the intended harm, and belligerent nexus. Your Excellencies, these criteria have been fully satisfied in this case. We can see that from paragraph 20 particularly, as regards the persons who were attacked at the Old Town Plaza, that the ULF militia had circulated pamphlets instructing civilians to come out and establish roadblocks to halt the advance of the Kenimboye Armed Force. Your Excellency, the ICROC lists as one example of direct participation, establishing roadblocks to block the deployment of military personnel in a particular case. Your Excellency, in this case, these persons did not just halt the advance of the Kenimboye Armed Force, but there was a ULF militia positioned in a building where this roadblock was established, holding a rocket-propelled grenade. Your
Council,
Excellency, the deployment of a rocket.
as to the value and relevance of the ICRC's famous guidelines on direct participation in hostilities, how exactly are you treating this particular instrument? Is it a legal source? Is it a relevant document? Is it a soft law? Could you please clarify that before you proceed? Thank you.
Yeah, thank you very much, Your Excellency. Your Excellency, the ICRO guide is not a binding authority before this court, but it is a persuasive authority as it will guide the court in the determination of the issues before this court. Your Excellency, the ICRC is an international organization which has been recognized worldwide as an authority as regards international humanitarian law. Thus, the documents and the publications of this particular organization is deemed to be a persuasive authority as regards armed conflict and matters of international humanitarian law. Thank you very much, Your Excellency. Your Excellency, as I was saying, there was a ULF soldier positioned with an RPG in a building close to where this persons had established roadblock. The deployment of this weapon would have led to the destruction of lives of the civilians who were there and even members of the armed force. They basically made the Kenimboye armed force sitting ducks open to an attack. Your Excellency, this qualifies as direct participation in hostilities. First, these persons had lost their protected status. Nevertheless, it will be stated that the attack was still not intentional, as we can see that the deployment of the Better Target AI was because the civilians had resorted to throwing stones at the members of the armed force, and this was what led the Better Target AI to categorize these persons as hostiles. There was no predetermination from the onset to attack these persons, and even for the case of persons who were injured at the by the Adam software at the St. English Church and the Mountain View Sanatorium, there was no intention to attack civilians, Your Excellencies. These persons were killed because they unfortunately were in a place that is, for the purpose of international humanitarian law, a military objective. Your Excellencies, the fact that these properties are a military objective is going to be established in the next issue, which is whether they were attacks on protected property. Article 28, the sub B10 of the Malabo Protocol states that intentionally directing attacks against buildings dedicated to religion, education, and even hospitals is a war crime. The question before this court is whether the St. English Church and the Mountain View Sanitarium constitute military objective in this particular case. Were they being used for military purposes? We must make recourse to the statement of fact. But first, Article 52 sub 2 of Additional Protocol 1 defines military objectives as objects which by their use, location, or nature would make an effective contribution to military operation, and the neutralization or destruction would also give a definite military advantage. Your Excellency, paragraph 24 of the Statement of Agreed Facts reveals that the Adam software carried out an intelligence operation gathering information as to the hideouts of the ULF militia, and it discovered that the church and the Mountain View Sanatorium were being used as meeting points for the ULF militia. They were being used as command centers, and they were being used for the stockpiling of munitions. Your Excellencies, these factors categorize both buildings as military objectives, because they did not have any protected status as at the time of their attack. There is therefore no ground to substantiate the claim that they were attacked on protected properties. It is therefore the submission of the defense that the court makes a declaration that there are no substantial grounds to substantiate the claim that the crimes of unlawful confinement, intentional attacks against protected persons, and attacks on protected property took place in Uri.
Counsel, I'm sorry, I have to clarify here because of the technical problems. I can't properly hear you. Could you please confirm again? Are you saying that the church and the sanatorium, they did contribute to military action, or they did not contribute to military action?
Thank you very much, Your Excellencies. It is a submission of the defense that both buildings contributed to military action as they were being used as military objectives.
Oh, thank you. Clear.
Thank you very much, Your Excellency. Thank you very much, Your Excellency. Gratefully obliged. Your Excellency, on the last issue before the court, the question is whether there are substantial grounds to substantiate the claim that Ms. Lushomo Ngala can be individually criminally responsible for the crimes alleged. Your Excellencies, it must be stated that the standard of proof in criminal cases is proof beyond reasonable doubt, and this the prosecution has failed to do. Your Excellencies, Article 28N of the Malabo Protocol states certain modes of responsibility would determine whether a person has committed an offense. Your Excellencies, all the provisions of this article have not been established in this case. In order for us to establish culpability, criminal culpability, two elements must be established. They are the actus reus and mens rea. The actus reus refers to the physical element, and the mens rea refers to the mental element. The case of prosecutor and the like is quite instructive on this point. It says that in as regards acts which do not. Yes, Your Excellency. Yes, Your Excellency. I can hear you.
To be fair to you, I can't hear you quite clearly. If you can adjust your gadget so that I can follow your arguments.
Oh, I'm sorry for the network issues, Your Excellency. Can you hear me better?
That is better now.
Thank you very much, Your Excellency. Once again, I apologize. Your Excellency, I was saying that in order for us to establish criminal culpability, two elements must be established, and they are the actus reus and mens rea. Your Excellency, the case of prosecutor and Belalek is instructive on this point. It says that as with regards to acts which do not constitute direct performance of the crime, actus reus refers to acts that contribute to or has an effect on the commission of the crime. And the mens rea refers to knowledge that the act of participation will assist the person committing the crime in committing the crime. Your Excellency, in application of these rules to the statements of facts, it is a submission of a defense that the requisite mens rea to convict the defendant has not been established by the prosecution. First of all, paragraph 6 of the statement of facts refers to us that the defendant had the belief that artificial intelligence will significantly improve lives and make the world a better place. Your Excellency, from paragraph 14 of the statement of facts, the defendant did not know that the Alpha software was to be deployed on residents in Uzuri. From paragraph 18 of the statement of facts, we see that the intention of the defendant, the knowledge on which he provided technological support, was to aid in the distinction between civilians and combatants. Your Excellency, the principle of distinction is sacrosanct in every armed conflict governed by international humanitarian law, as there must be a distinction between civilians and combatants, and civilian objects and military objectives. This was the intention of the defendant. Also, in paragraph 22 of the statement of facts, we can see that the Adam software was deployed to help distinguish between civilian objects and military objectives. Your Excellency, we can also see from paragraph 19 of the statement of facts that the deployment of the target AI was reported to have mitigated in the loss of lives of civilians. Your Excellency, the defendant in this case is a heroine, as she used her expertise to ensure that there was no grievous loss of lives and destruction of protected property, which is often rampant in any armed conflict. The prosecution has failed to establish that she had the requisite mens rea which is required to convict her for the crimes that have been alleged. It is therefore our submission that the court makes a declaration that there are no substantial grounds to substantiate the claim that Ms. Lushomo Ongala is to be held individually criminally responsible for the crimes alleged. And it's on this point that the defense would rest its case. Thank you very much, Your Excellencies. I'm very grateful.
Thank you, counsel. Despite the technical challenges, I think we got the majority of your statement. Now, I would like to ask if the prosecution is going to use its right to rebuttal or is it going to waive it? Could you please clearly state it? The prosecution. Mr. Wenger, could you please turn off the timer if possible?
Could you please repeat the question? Sorry, I was experiencing a bit of a technical issue.
Now we can hear you. Thank you. I was asking whether or not the prosecution is going to use its right to rebuttal, or is it going to waive it?
Yes, we will use our right to rebuttals right now.
Okay, then you may proceed, please.
My co-counsel who's supposed to take us through the rebuttals is requesting for some time. He's experiencing a bit of technical issues on his end, if the court may allow.
I think we can wait for some time.
Due to the technical issues my co-counsel is experiencing, I'd like to be the one to take us through the rebuttals. Your Excellencies, as the defense has provided, they first started by stating that complementarity is equated to exhaustion of local remedies, but it's our position as the prosecution that complementarity does not mean exhaustion of local remedies. They further stated in their submissions that the sanatoria and the church were not protected areas due to the fact that they were aiding in military operations. Your Excellency, it has clearly been stated that these areas were near bases for military operations. The fact that the sanatorium was in a ULF-controlled base does not mean it was being used to aid a militia operation. It should also be taken to note that this sanatorium and churches were built way before the wars between the ULF and Kedibonye government ever began. And then there's also the factor of mens rea. The mens rea was proven by the prosecution in such a manner that Kedibonye government had deliberately launched these attacks on the people of they had launched attacks on the people of Uzuri. The prosecution had stated that Kedibonye government
I think you're frozen, counsel.
Had not done so, but it is clearly. Can you hear me right now?
Right now, we can hear you.
Sorry about that. I was giving mention to the fact that the prosecution alleged that the concept of mens rea was not efficiently proved and was not substantiated in this case. It is our position as the prosecution that the concept of mens rea was indeed proven due to the fact that the Kedibonye government had launched an attack 10 days later to a sanatorium, killing medical officers. This is to mean that these people had deliberately taken time to plan and strategize in order to launch these attacks against the sanatorium. That being said, I'd like to ask for 1 minute in order to allow my counsel, who's supposed to take us through the rebuttals, to do so.
Yes, the time is granted.
Your Excellencies, can you hear me?
Yes, we can.
I'm having some technical problems with my video. Is it fine if I proceed?
If your video doesn't work, we can hear you. You don't have to turn it off if it's helping with technical problems. You don't.
Your Excellencies, much obliged. Your Excellencies, we submit that the exhaustion of local remedies is not a requirement for a party to launch a case before this honorable court. The complementarity doctrine is not similar to the exhaustion of local remedies. What it does, it gives a state party the first right to remedy a wrong that has taken place in its country. In this case, further, it is the prosecution versus the accused. It is not the country of Salima. Therefore, the contention that Salima must exhaust the local remedies is completely unfounded. Thirdly, there is a procedure in which, in lifting the protection status of protected property and additional protocol 1 in its article 21, where a warning needs to be given to such protected property where its state of protection will be lifted. However, no such warning was given, no such notice was given, and therefore this property still retained its protected status. With that, the prosecution rests.
Thank you, counsel. Would the defense forego its rebuttal, or would it like to use it?
Your Excellency, we intend to use our 5 minutes that we reserve for rebuttal to make some rebuttals.
All right, please do.
Can Your Excellency hear me?
Yes, we can.
Okay, thank you, Excellency. My first rebuttal is with regards to the principle of complementarity, Your Excellency. The first speaker has made an assertion before this court that complementarity does not entail exhaustion of local remedies. She just made a blanket assertion. She did not tell us what it is. She just told us that it is not. Then what it is? Complementarity doctrine is to the effect that national court or domestic court of a state must, or a state must make attempt to investigate or prosecute a matter before referring it to an international criminal court. Your Excellencies, that is the principle of exhaustion, the investigation and prosecution by national court or by a state is the exhaustion of local remedies in this instant case. And as such, our assertion does not have any law or fact to support itself. She did not assert any law or fact to support our assertion. Excellency, with regards to our assertion that the defendant does not have mercy for the crimes that she's being charged of, the defendant has objected that she has the necessary, that Kedibonye government has the necessary mercy. However, Your Excellency, it is not the Kedibonye government that is before this court. The Kedibonye government is not the defendant in this instance case. We are asserting that the defendant, which is Lushomo Ingala, does not have the necessary mercy. We are not saying that Kedibonye does not have necessary mercy, which she's objecting to. Thus, our objection goes to no issue. And lastly, Your Excellency, is with regards to the gross breach of the rules of this competition, particularly paragraph 14.1 of the rules of this competition provides that only one counsel can make a rebuttal. And before this court, we saw that both counsel made the rebuttal. It shows that they are not abreast with the rules of this competition, and they should be penalized for this, Your Excellencies. And it is on this basis, Your Excellency, I conclude my rebuttal. I am grateful, Your Excellency.
Thank you. Is the second counsel going to contribute to the rebuttal or not?
we don't intend to breach the rules of this competition. It is only one counsel by paragraph 14.1 of the rules of this competition that can make a rebuttal.
Clear. Thank you. Thank you. I think that now I can announce this particular session ended, and then we'll proceed to deliberations in a different room. Thank you, teams, for your presentations.
Court is now adjourned. Participants and spectators should wait in the courtroom as the judges go to the deliberation room. Okay, so the judges are back into the courtroom. So at this juncture, the judges will be able to give you comments in regards to the rounds. And then, of course, the president will be able to declare the winners. But of course, first they will be able to introduce themselves. Mr. President, I hand it over back to you.
Well, thank you very much, Mr. Lengo. I would like to first give a chance to my colleague, to Judge Haseke, to introduce himself.
Thank you, Mr. President. As you have pointed out, my name is Haseke Jojadis. Just to the participants from Nairobi, Kenya, I am a lecturer at the School of Law of Jomo Kenyatta University of Agriculture and Technology. It has been an honor for me to participate in this in this round, the quarterfinal, beating two very strong teams. I must say it was a very close call, and I was thrilled by the level of preparedness. I was equally very happy at the manner that you delivered your presentation. And what I can point out is that, like any other contests, unfortunately, one party will proceed, another one will remain, but it is not for to say that there is a gulf, a very serious gulf of disparity between the teams. Perhaps just small things here and there that perhaps separated the two teams. But I must commend both teams for a presentation or arguments well delivered. I will make general comments for the two teams, and this is just for purposes of assisting you to improve. Of course, today's moot is not the end of perhaps your mooting experience, and you can take these comments going forward, either in this moot for those who will be proceeding, or in subsequent moots for those who may not be able to, but the other opportunities will present. So starting with the first team, I think I must comment both the councils for presentations well delivered once again. For prosecution council 1, I think I liked the composure and the ability to deliver your arguments in a very decisive and composed way. You did not seem to be in a panicky mode, especially when questions come in. And specifically, I cite out when I try to interject and ask you a question, you are able to pick out the fact that you are coming to address that, and you did address it when handling that. For the second presenter, equally, you did very well in terms of presentation, but I got this sense of I get the sense that you are too quick. I think you are more mindful of the time, and sometimes when you ask a question, you wanted to deal with it quickly without perhaps maybe being sure or confirming whether the judge who has posed the question is satisfied with your answer. So sometimes I think you need to find out, or just to gauge whether your answer has been taken in well by the judge. For the defense team, equally, the statements that I have made for the prosecution equally apply to you. And I think I like this style where when you start your presentation, you are able to tell us or to give us a synopsis of what you are going to rely on in terms of the instruments and even the case law that you are going to give. For the first defense counsel, perhaps you just need to have a situation where you need to reduce. It is not a matter of life and death. You need to work around that, where you are measured. You are able to explain. I think when we were dealing with the issue of jurisdiction and the issue of the applicability of the Malabo protocol, you seemed to be very much emphasizing, and I think it almost had to be. It appeared as if it is an exchange between the bench and yourself on whether the protocol was applicable or not. So I think you just need. I know sometimes there can be pressure in such an exercise, but I think that can assist going forward. For the second council, I think she did very well. Unfortunately, we had those technical issues, but this in no way affect the perception or my view of how you delivered. I think you did very well. The only thing is which I thought, and perhaps it's not a bad thing considering the timing, is sometimes you went too quickly, that I would making that point that perhaps you wanted did not come out very well. So those are my comments going forward. I think in terms of the confidence, all of you exhibited the same, and even where we had interruptions, be they technical or perhaps questions from the judges, you are able to answer them and go back to your chain of thoughts. And for that, I would really want to thank all of you for preparing very well and for executing your arguments very well as well during your presentation. Thank you very much, Mr. President.
Thank you, Georgiadis, very much for your detailed feedback, for your comment. Dear participants, let me first introduce myself. My name is Rustam Otajanov. I am from Central Asia. I am an associate professor and associate dean at the KIMEP University School of Law in Almaty, in Kazakhstan. I teach mostly public law and international law and criminal law related courses, and I also teach international humanitarian law course, which I produced here, and I teach it myself at the law school for undergraduate students. I would like to, maybe I'll be repeating what my colleague previously said, and before I announce the winner team for the quarterfinal, I would like to also share a couple of points on my side, at the risk of again, reiterating what my colleague said before. First of all, it was a close call. Really, it was not easy to choose between the two teams, because both of the teams, and that means all four oralists, they showed a higher level of preparation. They showed confidence. It was clear that you are aware of the facts, that you know how to use the facts. You prepared in terms of knowledge of the substance of the law, applicable law, and so on. So your composure, your presentation, how you hold yourself in front, even if it's an online format, hold yourself in front of the panel. All of that showed that you really took it very seriously, and that made our job actually not so easy. Yes. In terms of more precise feedback, I would like to first of all mention to the first team, to the prosecution team, that it's always important to consider in detail and analyze in detail all the applicable elements when you're qualifying conflict. You have to be very clear about what type of conflict you're dealing with, because that by itself, by default, will determine what rules you're going to exactly apply. So just don't wave off any relevant elements that you have in your particular case, because that can be very important. That can be very crucial for building a successful case in front of the court, whatever court you're dealing with. It can be in regional court, in international court. So that's very important. So when I was asking you questions about IAC, NIAC, so that's what I meant. Yes, analyze everything in detail. Analyze the status of the state or non-state actors involved in the conflict, in the armed conflict, because that will help you exactly to deal successfully with the provisions that you have to apply, be it Article 2, be it Common Article 3, be it articles of the additional protocols to the Geneva Conventions, and so on and so forth. Your timing was actually for both teams, time was, I think, a little bit of challenge, because you requested for your main, all of you for your main statements requested additional time, but that's okay with the rules, so it's not playing a determinative role in our assessment here. regarding the defense team, I would like to join my colleagues' words and repeat that indeed, how to say, this is not a matter of life and death. Indeed, this is a moot court competition, which is supposed to bring out your knowledge, which is supposed to teach you something new, something substantive about the topic that you're working on. It's an opportunity always for any participant to learn from and to enrich the experience, enrich their knowledge. So in that sense, I'd say that I'd advise you to take it like that. Just like the first team, you also did a very good job in terms of replying to each and every question. You didn't forget the questions. You tried to address them consistently. I would praise you for that. Also, I would like to tell you that when you deal with the status of international or regional or other types of organizations, yeah, you have to be also quite aware and clear, because it determines the rights and duties of those particular organizations. Their legal status is important. So, for example, when we talked about the guidance, the well-known guidance of the ICRC, International Committee of the Red Cross on Direct Participation in Hostilities, ICRC is not exactly an international organization. It's not. It's governed by Swiss law. It's a private humanitarian organization which is helping those who are negatively affected by the armed conflict. It has an international mandate, that's for sure. That's given by Geneva Conventions. It's actually a unique case where a treaty under international law provides such a role for an organization. So yes, please keep that in mind. And yeah, the principle of principle of legal certainty it's important for any kind of lawyer, be it international, be it domestic. So I would like just to point that out. Your level of preparation was also very, very good. I liked it. Also, let me move to the next very important point. The judges took seriously into account the point that the defense team raised during their rebuttal, that is the violation of the rule on participation of the co-counsel in the rebuttal stages. Okay, this is seriously taken into account by us. It will be reflected in the scoring sheet, and this has been taken into consideration when we were making our decision about the winning team. So please rest assured of that. We didn't forget it, and it's serious, so we took it into account. Now, that's my feedback that I wanted to give you. There are more points also on a more technical level, but I would like to, I don't want to take too much time on that. Yes, Mr. Wenger?
Mr. President, so before you announce the results, I'll ask the teams to be able to put their cameras on.
Mm-hmm. Okay.
Defense team, are you there?
Yes, Your Excellency, we are here, but we are having issues on.
Okay. Mr. President, you can proceed.
Okay, it's problem. What is popular is that the problem is the who stop our camera like that.
All right.
You cannot start your video because the host has stopped it.
Okay. But you can hear us, right? You can hear us clearly. Can you confirm?
Yes.
Okay.
We can loud and clear. Okay, we can start it now.
Mm-hmm. And you heard our feedback, both of us, right?
Yes, we heard it quite well.
Okay.
And we are grateful for it.
Okay. Then I think I have to now announce the winning team for the quarterfinals. After carefully considering all the important, relevant points based on the rules of this international humanitarian law moot court competition, The judges for the quarterfinal would like to announce the prosecution team as the winning team, but coming very, very close to the defense team in this. Please keep that in mind. And again, let me tell you that the penalization that was mentioned before, it's going to be considered, it's going to be reflected. Nobody forgot about that. It's a competition. This is not a question of life and death. And please keep in mind that both teams, I hope really that both teams today learned something useful, something helpful for their future careers, for their future studies, and they will be able to apply it in their future knowledge. I would like to thank all the oralists for their hard work, for their hard efforts. We are very appreciative for your contributions, and hopefully we'll see each other in the future in other competitions. Thank you very much. It was an honor for me and for us to participate here and to work with you. Thank you.
Thank you very much, Mr. President. Thank you very much, Judge Kaseke. To the teams, thank you very much for your participation. Just a few points to make. One, so I just want to reiterate what the President indicated. This is not a life and death issue. So when you should take whatever you have learned from the mood and be able to use it in future, because whatever has been tackled in the mood problem is current affairs. There are discussions. At the moment, at the United Nations, there is a discussion in regards to whether to have a convention on the question of autonomous weapons in terms of regulating them, which is what you guys are covering in the mood problem. And therefore, use that knowledge in order to be able to progress beyond that, and that's the whole essence and the whole goal. We understand that it's a competition. Of course, we have to have a winner, but it is not the end of it all. So we will be able to publish the schedule for the teams that are progressing for the semi-finals once we have completed all the rounds. So we have one quarterfinal remaining. Then we'll be able to send in the schedule for the semi-final starting tomorrow. I'll now give the opportunity to Mr. Abdulkarim Aziz, the FIS president.
Thank you so much, Mr. Vice President. Special appreciation to the President of the Court, Dr. Rostam, all the way from Central Asia, for your time, for your commitment, for this fatherly word of wisdom you've shared with the participants. We appreciate it a lot, and we thank you so much for your time. And to the court judge, to chair this, thank you so much all the way from East Africa. We appreciate your comments and also your sacrifice in ensuring that we have better scholars in Africa. Thank you so much, sir. To the participants you've had from the judges, those are true reflection of the performance today. And I hope you have taken it in good faith. And for us as organizers, it's more than the moods. Like the Vice President rightly said, this is an ongoing debate, even at the international level. And so to involve students, university students at this stage is something greater than what you can ever, envisage. And so I want to encourage you to do more. I want you to see this as a platform to do better things in life. And you have opportunity to meet students from other universities across Africa. You have opportunity to relate with senior judges, people who have been doing this for the last 20, 25 years. So utilize that options, get in touch, network. That is some of the things that competition of this standard, provides. So if you want to find yourself in Central Africa, you know that Dr. Rostedam is there for you. If you want to go to East Africa, you know that you have, people that can even give you recommendation based on what they've had and seen today. So you want to apply for a scholarship, you want to go for your LLM, these are people. So utilize this platform. Do not see it as if it's a winner or loser thing. For us, that was not the intention. We want to involve young African scholars in this international debate so that universities can send some of you to the UN and represent them. And you'll be able to make meaningful contribution. And for us as organizers, we can also recommend and say, okay, we want to be part of this discussion. And we have a team of students that are competent, and you'll be able to give valid contribution, and we can be rest assured that all these contributions will be taken into consideration when something serious is going to come out. So for your university nominating you to be part of this is a success. For you to have come this far is a success. And for everything that will come after this is also a success. So do not
I think there is a
relations network with other members, find out what they're doing in East Africa and in Central Africa that you're not doing. At the end of the day, everything will be fine. So on behalf of FIS, I want to thank everyone once again for the commitment. And with that, this brings us to the end of this session. Mr. Swale, thank you so much for the organization, and all the best to everyone.
Can I say,
the President had something? Yes.
Yeah, I think it's, sorry for taking additional minute, but I think it's very important. I wish I could tell dear participants, I wish I could tell that international humanitarian law is irrelevant today, but unfortunately I cannot tell that. We still need in 21st century all the tenets, principles and rules of international humanitarian law, be it in the African region, be it in the Asian region. We are right now here in Central Asia, living very close to the place where the conflict is raging. Russia attacked Ukraine, and I'm also asked advice regularly about the application of IHL and international criminal law rules to that particular conflict. We are constantly reminded about IHL rules, and I think that just like my dear colleague, Mr. Abdul Kalim said, the United Nations, or maybe international community in general, needs bright young specialists like you. They do need you. So I join in his words in terms of please use the available resources, use us, use this competition in order to play an active role, an active part in disseminating those rules. We still need IHL rules to apply. We still need those principles to reduce the consequences, humanitarian consequences of the armed conflict. So I would like to say that I was very pleased and honored to work with you today. And I'm thankful to my colleagues here and to Georgi Adis also to do this important work. Thank you. Have a good luck to your